in civil litigation. He's also the head of the program at the University of Toronto Law School in trial advocacy, the most popular course there, with full enrollment. And I'll turn it over now to Ron.
Thank you, John. Watching the, and trying to come up with some way of dealing with the material, I have been given sort of a grab bag of things to talk about, other procedural points that are relevant in the general question that we're dealing with here. I don't propose to go through all of them. Some I've dealt with in more detail than others, but I do intend to review the question of foreign currency, and I hope that I will take you to the paper and we'll deal with it quite specifically. It's a very interesting area and one that is seemingly, from the cases that are coming along and also just the general trend to international litigation, is becoming quite important. And then what I propose to do is to deal with problem number 6, which I just saw for the first time this morning myself, so I may get it all wrong, but it strikes me that there are elements in problem number 6 that might make clear what I was trying to say in the section of the paper on currency and its conversion, so that if you're otherwise bored listening to me, you might want to read problem number 6. Before I get to that, though, there are a couple of things that, now that I have the forum, that I would just like to say about some of the things that were said this morning. The forum shopping question and Earl Cherniak's discussion about the Douglas aircraft case and Ken Howie going down there to try to attack Douglas where it lives. I had a case involving the Boeing Company. And as you probably know, the Boeing Company hangs out in the state of Washington and is the, I'm sure, the single largest employer in the state of Washington. I was acting for the purchaser of a Boeing airplane that crashed and had to sue Boeing for alleged design deficiencies. And the contract that Boeing insists upon and never deviates from in the sale of its aircraft is an amazing piece of work. And as usual, lawyers only get to look at it after something has gone wrong. And it specifically calls for the issues to be determined according to the law of the state of Washington. And the state of Washington has a number of cases, all of which start with somebody else's name, and the defendant is always Boeing. And the law of the state of Washington, you can be sure, is read into the contract that everybody who buys a Boeing aircraft signs. So there you are. And it's interesting to compare the state of Washington against California, where Douglas is in trouble because of the law there. The other point that I picked up, and I know Master Sandler might have something to say about this, is I'm involved in the General Motors Forenza case, which is a class action, and on that point has been going for about 10 years now. It's in the Supreme Court of Canada now, waiting to see whether it's going to be allowed to continue, but Earl Cherniak made the point that he didn't think he could compel from Ford Canada any of the design material. I found that a rather interesting proposition. We have been operating and defending General Motors on the basis that even though General Motors Canada didn't have anything to do with the design or even the putting together of this automobile, that if the crunch comes to the crunch, rusty forenzas and all that went into making them rusty, the design information and all the equipment material would be compellable on production. So maybe we don't have as much to worry about as I thought we did if Earl is right. The question of conversion of a debt into foreign currency, I deal with at the beginning of the paper. And if you'd look at page 157, this section of the paper is concerned with a very interesting point in the law, and that is whether or not you may assert a claim in the currency of the country where, to take one example, the breach that gave rise to the claim occurred, or to take a more common example, whether you may assert a claim in the currency that is provided for in the contract, which might strike you as a rather obvious proposition, but because of a statute in Canada, our law in Canada provides that you may not, and that any judgment that is given in Canada must be given in Canadian currency. So that if that is the law, and it seems to be, although you'll see in the paper there's a discussion about whether it ought to be the law and whether it necessarily has to be the law, the next question arises that if you have to give a judgment in Canadian currency, how do you convert and when do you convert the claim that's in the foreign currency into Canadian currency? And that is a very interesting, I think anyway, a very interesting area of the law, which may be undergoing some changes and which is, of course, highly relevant today because of the fluctuations in currency. The practical reason for worrying about it is whether the Canadian dollar goes up or down, the plaintiff or the defendant will get the benefit or the detriment of the change in currency. And when we discuss problem number 6, we'll talk about that. I have set out on page 157, there are 2 numbered and there is a third, which begins with the paragraph on the other hand, the rules that are really the traditional rules. And I'd just like to highlight those. Under little I-1, the first rule is that the date for conversion of a debt expressed in a foreign currency is the date on which the debt was payable. Now, what that means is if you have a case where there's and the best way of describing it is an invoice debt. In other words, if somebody has supplied some goods and services and renders an invoice and those are not paid for, the traditional cases, and the traditional case is the Custodian versus Blucher, says that when you come to sue, the date for conversion will be the date the invoice was due. So that if the invoice were rendered a year ago in American funds and not paid, then when you come to the end of the judgment, having obtained a judgment because the invoice was not paid, you look back to the date that the invoice ought to have been paid, and you look at the conversion rate from US into Canadian dollars on that date, and that's the date. That's the traditional rule in that kind of case. Point number 2 talks about damage actions, a breach of contract or a tort. And the principle that's set out in those cases is that the date for conversion is the date of the breach. And that, I think, just follows the natural logic of our law that looks at the date of the breach for things like mitigation, damages, calculation of damages, and conversion of the foreign fund. The third rule is the one that's set out in the next paragraph and flows from the Batavia Times case, which is a case that discusses this whole issue, and I commend that you read that case if you ever get into this problem. And it stands for a number of things, but one of the things it says is that if you have an action on a foreign judgment, the date for conversion of the foreign judgment in the foreign currency is the date of the local judgment, or the date that you obtain judgment in Ontario. So there are 3 different time periods that the cases have set up to make that calculation. And this is important in and of itself, but also, and we'll see it when we look at problem number 6, for determining where action should be brought. Because often enough, when you have a foreign currency involved, you also have a choice of where to bring an action, because you have multiple parties, you have foreign defendants, you have claims in another country. So these rules can be quite important. Now, under the little I-1 on 157, you'll see a couple of cases, Gross versus Marvell Office Furniture and Airtemp Corp versus Chrysler. And those 2 are interesting cases. Master Sandler was involved, I don't know in both, but certainly in one. And the way they went up was on the question of whether or not a special endorsement that asks for payment in the special endorsement other than as of the date of the writ of the special endorsement is a proper special endorsement. The point being that when you're doing a special endorsement, as you all know, you calculate the amount owing up to the date of the writ. And a question arose as to whether or not that was the proper date to do that calculation. And what's interesting about these cases, and I'm not going to get into this aspect of it, is that in the discussion of that principle, the appeal courts seem to have gone beyond that and are now changing the law of number 1 that establishes that the invoice date is the date for a debt to what is the reasonable date. And it's a very interesting exercise, and I will refer you to the air temp case, which was an appeal from the master to Mr. Justice Montgomery, and from there an appeal to the divisional court. Just as an aside, when I was doing civil procedure here and generally in my own practice, I think virtually all the time stay away from special endorsements. I find they just often bog you down and cost all kinds of time, and you can get an action on for trial if there's going to be a defense, when most of them are defended, without the bother of, even though you're entitled to it, issuing a specially endorsed writ. And I just note that the master made the order in this case on April the 15th, 1980, and he ordered the special endorsement be struck out and it be amended. It went to weekly court, it went to the divisional court, and this judgment is a year later, April 15, 1981, and the issue that they're talking about here is whether the special endorsement is proper or not. So there's a year in the litigation process that is gone for some client, and the end result of the case is for the judge to say, well, it's a matter for trial anyway. So it's one example of the time not to use a special endorsement. But in any event, Mr. Justice Montgomery turns his attention to these old cases about the fixed times for conversion. And he imports what I guess is refreshing into this area. And he says, in my view, the economic exigencies of galloping inflation and interest rates demand a modern approach. The most compelling conversion date must be the most recent reasonable date. I am therefore of the view that the date of issuance of the writ is the appropriate date for conversion of American to Canadian currency. So in one fell swoop, if this is the law, the old line of cases that says the conversion date is the date of the debt would not now seem to be the case, at least for Mr. Justice Montgomery. Now, it went to the divisional court, and they didn't really turn their mind to that issue. They said, in essence, we agree. So there it is. And the importance of it, at least if you look at it in a sort of historical or a policy way, or try to get some rationale for this, is that there seems to be a view that's advanced in some of the other cases, which I won't go through, also discuss it, of extending the conversion date. And that is the English principle. As I say in the paper, the English are not affected by the statute that prevents us from doing it, and they have long passed the old law and now reached the point where they have what's called the rule of effect, the date of effective payment. And it works this way. In England, you now get a judgment in the foreign currency. So they will give you judgment for 50,000 American dollars. And that's the judgment. So that you're entitled to the currency in which the debt was contracted for, which, after all, you should be entitled to. They then go on to say that if the payment is going to be made in sterling, then the conversion date is the date upon which you are paid. So that they take the conversion date right along as far as they can with the substance of the litigation, and when the litigation ends, that's the date of conversion. Now, there's an argument, and you can sort of kick it around in your head as to whether that's good or bad, because the answer is it depends on what happened to the currency in the meantime. But it is interesting that the English rule has deviated quite substantially from our own. All right, well, what I propose to do now is look at problem number 6, because I think with this discussion that I've given to you and a review of these cases in the book, this may have some value in trying to put this into real-life terms. If I can find my notes. The fact situation is actually fairly simple. Company X entered into a contract with Company P. The contract was negotiated in England, and it called for Company P to distribute Company X's goods in France. Upon entering into the agreement, there was to be a $50,000 payment for the right to distribute the goods, and then there was to be a 10% royalty or commission payable on sales. So that you have two different currencies, two different times and circumstances under which payments are to be made. You have 50,000 American dollars, and you have a 10% royalty on gross sales. The questions, I think, probably exhaustively canvass whatever can be taken out of the problem. I'm not going to deal with them all. The other important fact is that the law of the contract was said to be Ontario in the agreement. Now, the first question is asked, should X company commence an action in Ontario or refer the client to solicitors in France? Well, my suggestion, because of what I've been asked to talk about, is that one of the major considerations that should go into that decision is what is the state of the currency and where is it likely to go in Ontario, in France, and I would think in England, where you might well consider starting an action. So that when you have these questions, you should ask yourself, what is the state of the currency, as well as all the other things you've been told today to ask yourself. Now, I'm not going to give an opinion on an action under Rule 25, but if you look at page 67 of the materials where Rule 25 is set out, I'm sure you could work up an argument under Rule 25(1)(f) that Ontario does permit an action to be started under that section of Rule 25. But the good question is, of course, why would you do that when P Company doesn't have any assets in Ontario? And if it did not attorn to the jurisdiction, the judgment would not be worth very much. As to going to France, the facts are not clear, but ask yourself, what are the possible defenses? If one of the defenses is the products were no good, then you get into this question again of the design of the product, which will make the forum conveniens probably the place where the product was designed, which would likely be Ontario. Although, when you look at the facts, because they didn't pay the first $50,000 on the initial entering into the agreement, you would think that then maybe the defense isn't a design deficiency. But in any event, is Ontario the forum conveniens? Question 3. Well, then you trot up all the things on both sides of the coin that we've talked about today. Where are the witnesses? That would depend on what the nature of the defense is. Certainly most of them would appear to be in England at one point or another. The contract calls for the law of Ontario to be applied as these papers set out. There's a tendency to give prima facie effect to that kind of clause. But then you get down to the choice of jurisdiction on the basis of currency conversion. And if you were to apply the law, as I think I understand it to be based upon what I've told you and what's set out in my paper, analyze the problem from that point of view, and you ask yourself, what is the nature of the $50,000 debt? My suggestion is that that $50,000 debt falls within the first point, namely it's a debt that was due upon the rendering of an invoice, and therefore you would say to yourself, well, if we follow the old law and I sue in Ontario, I'm going to have to convert US dollars to Canadian dollars. I'm going to have to convert it at the date the invoice wasn't paid, which presumably under these facts I think would be January 1, 1982. So then you say to yourself, all right, how have I done from January 1, 1982 to May, whatever we are now? And you can do an analysis of where does the currency conversion leave you as of now, assuming you proceeded by some sort of specially endorsed writ and you were looking to get a judgment here? Well, we all know what's happened to the Canadian dollar since January 1982 to today. So you ask yourself, how many Canadian dollars am I going to get for my 50,000 US? And you can work this in to your analysis of whether or not you'd start an action in Ontario as one of the considerations. Then you look at the second part of the problem. What about the French franc? I think, although I'm not sure, well, I shouldn't say. I know Bill Graham would probably know what's happened to the French franc, but I don't. But you would go through the same process, but you'd have to ask yourself a question about the French franc. What kind of a claim is this? And my suggestion to you is that it's a breach of contract claim, and therefore may well fall within the second branch of the three that I've set out for you, in which case the date of conversion for that claim would be the date of the breach. And that in turn may involve you in some problems because presumably 10% would be payable on a continuing basis. But I'm going through this exercise to try to give you some realistic view about how these rules would actually work in practice. And then to contrast those, turn your mind to the English rule, which I've set out in the material and briefly explained to you here. There, the rule is that you would get a judgment in 50,000 US dollars, you'd get a judgment in 10% French francs, and that would be your judgment. So if you were to be paid in sterling, it would be converted at the date of effective payment. So you'd ask yourself, how is that going to work out in the analysis, and you'd proceed on that basis. All of that is a bit of an academic exercise, but I hope you, with working through that problem, can see that it is an important consideration in questions that give rise to this kind of claim to look at the date of conversion. There's only one other thing that I want to say, and Sheila Block did mention it, and also said that I did, and that is the changing law in the question of a stay of proceedings. As was mentioned, and you will say in the material, and I just highlight this, I'm not going to go into it, but if you have a case where you have actions in two different jurisdictions, the old rule was that you could only get a stay if you could show that the second action, say an action in England, was vexatious or oppressive. It was not a question of which jurisdiction is the better on the forum conveniens principles to consider and try the action. Now, the cases have not moved away entirely from the former position, but it is the case that they are moving away from the former position. And as I discussed in the paper, there may well be a sort of middle ground now where you can shift the onus by demonstrating on forum conveniens principles that where you want the action to be tried is the forum conveniens, and then you can shift the onus to the other side to demonstrate oppression or vexation or some other good reason why the stay ought not to go. And it's an evolving area of the law, and one that you should read the old cases and the old principles with a lot of caution, and I think there's a lot of room there for a sort of imaginative approach to it. In the time available and as the afternoon goes on, one last thing, you might want to know how you actually assert a claim in the lawsuit for conversion of your claim from American into Canadian dollars. And what you do in the statement of claim is just plead it. If you have a claim for 50,000 American dollars, you say in whatever body, in the body of the claim, and there's a debt of 50,000 US dollars owing to the plaintiff, and then in the prayer for relief, you say, the plaintiff therefore asks for judgment for 50,000 US dollars converted on the date of the judgment to Canadian dollars. And that is a form of pleading that has passed the inquiry of those who look at pleadings and determine whether they're proper or not. Thank you very much.
Thanks, Roy. The next topic on the agenda is dealing with probably an area that arises very often for a small practitioner or one that specializes in family law, and that's the question of the different issues that can arise in family law. Having read Tom Bastedo's paper, I find it frightening that now the rights of parties can be affected depending on where they move to after they've separated. Tom is a practitioner practicing with a firm of Bastedo Cooper, has been in practice for a number of years, and has been involved in normal litigation practice as well as being highly involved in the area of family law. Has been involved in the various subsections of the Bar Association and has spoken extensively in the area of family law and is very knowledgeable and has produced a very useful paper. I'll now turn it over then to Tom Bastedo.
I feel like a country cousin today, somebody who's been invited to a rather exotic party, or like a turnip perhaps in a bed of rhododendrons. The problems of family law really, while generally encompassing every aspect of our lives, have a really direct and significant impact on international and foreign law as well. In one sense, that's true, of course. In another sense, international law, as far as the family law practitioner is concerned, starts on the border between Mississauga and Toronto. And we have had a long and rather honorable history, I suppose, of dealing with international problems right in the province of Ontario. Rather than going into the more complicated issues today, what I wish to do is to talk about 4 or 5 specific and important directions which I think the law is going to follow in the next year or so. I wish to do this by considering a number of direct problems, and I got yesterday a South African marriage contract, came across my desk, and the first clause of the marriage contract says, "There shall be no community of property between the intended spouses, but each shall respectively retain his or her own property and effects." Now, every person in this room, sooner or later, will get a marriage contract come across his or her desk, and in order to understand how these marriage contracts are dealt with in the Ontario courts, it's necessary to look back, for instance, for a few moments and consider historically the role of marriage contracts. Now, as you all know, our world really is divided into 2 regimes, the community of property regimes and the non-community of property regimes. And historically, the function of the marriage contract in the community of property regimes was simply to opt out of the community of property. The marriage contract in our regime has an entirely different function. And the marriage contract in our regime is to specifically direct the attention of the spouses to the disposal of specific pieces of property. Historically, the old conflicts of laws, rules, which were established in the 19th century by the positives, do not really deal with this problem. And the result of it has been that the judges in Canada, at least, are ignoring the old conflicts of laws, rules in a real sense. And the result of this is that a marriage contract like the one I've just read will not be upheld in this province. Now, that's in spite of Section 2.9 of the Family Law Reform Act, which says very clearly, where a domestic contract makes provision in respect of a matter that is provided for in this Act, the contract prevails except as otherwise provided in the Act. Now, the courts have found 2 ways of getting around this problem. One of them is illustrated by the case of Hansen and Hansen in British Columbia, which is referred to in the material. And in that case, the result of applying a Swedish married contract would have been to give to one spouse $800,000 and the other spouse $1,000. Now, clearly, the courts found that this could not be upheld basically on the ground that it was against the law of British Columbia. And there's a series of exculpatory clauses in most of the conflict of law cases which I referred to in that case. The other way of getting around it is that in Ontario, in the case of Kerr versus Kerr, Mr. Justice Walsh stated really that the marriage contract, in order to be applied in this province, has to specifically anticipate and look at a specific type of property. Now, since that's not the function of the community property type of marriage contracts, and that, of course, includes Quebec contracts, in my view, it will be virtually impossible for a community property type of marriage contract to be successfully applied in this province. The second general issue which I wish to address relates to property where there's no marriage contract. Now, it is important to understand very clearly that some of the provincial statutes rely upon the concept of domicile, and some do not. Now, in Ontario particularly, and also in those provinces which generally follow the Ontario statute, that would include Prince Edward Island, the Yukon, and the Northwest Territories, there's a new concept brought in, and that concept is a concept of habitual residence. And we'll see as we go through this afternoon that the concept of residence and habituality and ordinary resident is a concept which is, in my view anyway, gradually replacing the concept of domicile. In any event, some of the other provinces, specifically the western provinces, use the concept of domicile. Now, once we use the concept of domicile, then we again are stuck with and follow the 19th century conflicts of laws rules. And these rules have very immediate impact for the determination of how property is to be distributed. And a starting point then is to take out one of the old conflicts of laws textbooks and look down the pages, and you will find rule after rule which will tell you what to do in a particular situation. Therefore, if there is a situation in which your client has different pieces of property in different jurisdictions, the first and primary question to ask is where ought the suit to be commenced? That question will be answered having regard to the type of property which is involved, whether it is movable or immovable, on the one hand, and on the other hand, the province in which the property is situate. Now, I wish to talk for a moment about immovable property. Immovable property means land. Historically, in Canada, in the Duke versus Andler case and in subsequent cases, the well-known rule has been applied that the courts in one jurisdiction will not interfere or transfer land in another jurisdiction. This, however, does conflict to some extent, this rule, by Section 13 of the Ontario Family Law Reform Act. Now, you will see in Section 13 of the 13.2 of the Family Law Reform Act, where it says the ownership of immovable property is between spouses is governed by the internal law of the place where the land is situated, for instance, Florida or British Columbia. The Ontario courts, however, have been given jurisdiction to divide family assets in this province having regard to the value of the property outside of the jurisdiction. Now, this rule has been very loosely interpreted, and following a general trend over the last 2 or 3 years of allowing the judges to equitably or exercise equitable jurisdiction in the Family Law Reform Act, what has occurred is that the judges are transferring property in this jurisdiction, whether or not it's family assets, because they can't do anything with respect to immovable property outside of the jurisdiction. Now, that's one problem. Another problem relating to immovable property is if there is immovable property in 2 different jurisdictions, in, say, Saskatchewan and British Columbia and in Florida, what do you do? Well, my advice in that situation is that, practically speaking, you start your action where the largest piece of property is situate. The most common problem in this province, curiously enough, arises through people who own condominiums in Florida and other property in Ontario. That seems to be a very common problem now. I'm involved in a situation now in which money was invested in Florida property. We have a trust problem as well. There's substantial property in Ontario. It's basically a very difficult question to deal with, and I don't have any easy answer. It may be necessary, and in many cases it is, just to start two actions. That's really the only practical solution. Let me talk now for a moment about movables. You'll recall that movables follow, in the absence of any statutory comment to the contrary, movables follow the domicile of the marriage. Historically, the domicile of the marriage is the domicile of the husband, and therefore, if the wife has movables in Saskatchewan, and she is still married, even if her husband is domiciled in Alberta, then her domicile is Alberta, whether or not she's in Alberta. Now, you all remember that, and that, of course, was changed by the Divorce Act, but in the Western cases, that rule still obtains. In Ontario, the rule has been altered and replaced by habitual residence. Now, you note that is in Section 13.1. The division of family assets as between spouses of movable property, wherever situated, are governed by the internal law of the place where both spouses have their last common habitual residence. So the point of that section is that the old domicile rule has been taken out of the Ontario legislation or whatever. Now, I wish to move on to talk about some other subjects, non-property subjects. On page 213 of the material, there's a reference to two cases. I do not wish to talk about those cases. The recognition of foreign divorce decrees is well known in this country now, and the case of Szabo versus Szabo just collects all the recent cases. The recognition of nullity decrees is virtually unknown and is extremely complex, and I wish to say nothing about it, but there's a very interesting and lengthy judgment in the British Court of Appeal in Gwynn versus Nellen, and that's in 213 if you ever run across a recognition problem. Now, as you probably know, there is an act called the Reciprocal Enforcement of Maintenance Orders Act, and the time of 4 provincial courts of appeal has been taken up, and numerous other judges, with the issue of whether or not that machinery is available to a person who has a divorce decree nisi giving to her or him relief. The issue being whether, if in Ontario, we get divorced in Ontario, we have an order saying that the husband pays the wife $100, can you then take that and get it enforced under the Reciprocal Enforcement and Maintenance Orders Act in Saskatchewan? Well, the courts of appeal in 2 provinces have said yes, and in 2 provinces they've said no, and there are at least 10 other judgments on this rather futile issue. And it seems obvious to me that the Supreme Court of Canada will state that the corollary relief can be enforced under the Reciprocal Enforcement and Maintenance Orders Act because it's the obvious solution. Anyway, you should be aware, I suppose, of that issue. I refer you to the case of Santa Clara, California, and Hudson on page 215. That case is an interesting case because it describes the difference between the American type of enforcement mechanism and our own. And as we have now many, many situations in which people are moving back and forth across the borders in this country, I commend that case to you. Now, the subject of children is a subject which has received much attention in the last 6 months, I suppose. I say it's received much attention because it has been the subject, of course, of extensive debate in our legislature in the form of the Children's Law Reform Act. Now, this act is virtually on the verge of being passed in Ontario, and it has important consequences for every practitioner. However, before I get to discuss that act, and I do not intend to discuss it in much detail, I will say the first question is always, will the court, when faced with an application for custody of children, assume jurisdiction? Now, this question was dealt with in a very interesting way in the Ontario Court of Appeal in a case called Shermans Song and Shermans Song. And in my opinion, the case was wrongly decided, and it illustrates the usefulness of the forthcoming statute. In that case, if I can just take a minute, Mrs. Shermans Song was a Canadian citizen who moved to Marseille and lived there for a number of years. To abbreviate the facts into some cognizant form, what occurred was that she married a French citizen. They lived there for a number of years and had a child. And one day, she left and took the child and went back to Brantford. Now, she took the child in circumstances which were abrupt, but there was no formal order in effect. Now, in Ontario, if the child had been removed, say, from Toronto to Ottawa, in these similar type of circumstances, there is no doubt that a master in the Supreme Court of Ontario on an interim application under these circumstances would have ordered the child returned. Now, Mr. Justice Lecourcière, who wrote the majority decision in, or the decision because there was just one in Shermans Song, refused to return the child and stated, and if I can just read this for a moment, on page 220, it was submitted by counsel for the respondent that the applicant, by removing the child from its home, family, and friends and from school before the end of the term without warning to the father, was acting in a way which cannot be countenanced by the court and which must be regarded as contrary to the best interest. In my opinion, this aspect of the wife's behavior is irrelevant for the purposes of jurisdiction. So what happened there was the court said, we don't really care what occurred, but for jurisdictional purposes, we don't even have to think about it. Now, under the new act, the Children's Law Reform Act, by section 22 of the new act, the following change has occurred. The court shall only exercise its jurisdiction to make an order for custody or access to a child where the child is habitually resident in Ontario. And then it goes on to say, although the child is not habitually resident in Ontario, the court is satisfied, and they're enumerated about 4 or 5 of their points. So the main issue or point that I wish to leave with you with respect to this aspect of our talk is that the habitual residence test, which is set out in the Family Law Reform Act with respect to property, has been brought into effect or will shortly be brought into effect with respect to children in this province. And in my opinion, if that act had been in effect, the Court of Appeal could not have decided the Shermans Song case in the way it did. I'll deal in a moment with other parts of the act. If you look at page 221 in the material, you will see a reference to 3 separate papers, and I commend all of them to you for different reasons. Mr. Shipley is in the policy development section of the Ministry of the Attorney General, and his lengthy and excellent paper discusses in detail the Hague Convention aspect of the Children's Law Reform Act, and I'll allude to that in a moment. Mr. Epstein and Professor McLeod talk in more general terms with the problems relating to children, and hence I commend those to you as well. Now, I mentioned that the seminal question in custody cases is when jurisdiction would be assumed, and in section 25 of the Act, the court is given specific power to decline to exercise its jurisdiction where it is of the opinion that it is more appropriate for jurisdiction to be exercised outside of Ontario. And this is the first time, really, that this particular problem has been addressed either in respect of children or property, because as I point out elsewhere in the paper, one of the difficulties that we have in property litigation, if we suppose, is that it's very difficult for a court to decline its jurisdiction, although the Prince Edward Island did so in the case of Keefe versus Keefe. Now, we've talked a little bit about the jurisdiction. In sections 41 of the new Act, 41, 42, and 43, the Act deals with extra-provincial matters. And there is quite a complex code which purports to deal with the problem of basically what you and I know as kidnapping. Now, you may or may not be aware that in virtually every province in this country except Ontario, there has been legislation in effect which has covered this problem for a rather lengthy period of time. And these acts, or the type of act, is referred to in page 225 of the material, the Extra-Provincial Custody Order Acts. In my opinion, the Ontario Act, while it is certainly more complex and more full, is not really that different from the other provincial acts, and I really don't want to spend the time going through them all, but basically what they say is that the court into which a child is taken will have the power to vary the other order, if you like. That's not very clear. Supposing there's an order in Nebraska giving custody of a child to the father, and the mother takes the child to Winnipeg. In Manitoba, the court now has the power to vary the Nebraska order if certain criteria are established, basically, which have to do with establishing a real and substantial connection between the child and Manitoba. If that type of connection is not there, and if there is no serious harm being threatened to the child, then the Manitoba Act says the child must be returned to Nebraska. So that, in effect, is a summary of all the legislation in Canada and in Ontario, basically the same type of legislation is brought into being. Of interest, however, is appended to the statute, there is an entirely different code. So we have two complete codes. The different code is the Convention on the Civil Aspects of International Child Abduction. And while I'm not very knowledgeable on this must be one of the first times that a provincial statute in this country has put an international convention right into the statute. Is that true? I would think so. In any event, the Act provides that once there is a signatory in an opposing state, say Zaire, for example, then the aspects relating to child kidnapping between Ontario and Zaire would be governed by the convention which is set out in the schedule. And so there are two completely different codes which are in being. I have one further topic just to mention briefly. We have been cursed, I suppose, in this country with numerous fights between the provincial and federal jurisdiction in family law. And one of the reasons for the substantial body of opinion which is held by most lawyers who practice in family law across this country, that there should be one uniform family law property type of regime, is illustrated by cases such as Saulnier and Saulnier, which is found on page 227. Now, I hasten to point out to you that I recognize that this will probably not come into being because of the property rights and so on. I'm not naive enough to think that that will occur. But nevertheless, the Saulnier case is a case which illustrates to its highest sort of conflicts which can occur. And in that case, without going into the facts, what happened was through an odd series of circumstances, there came into effect 2 interim orders, one in Nova Scotia and one in Ontario. And the court in Ontario had to decide what to do. The rule is found on page 229. Mr. Justice Wright, in a well-known judgment, stated, "The conflicts in federal and provincial laws with regard to custody of children are not resolved by constitutional law, but in each case by regarding the welfare of the child as a paramount factor." And he refers to Mr. Justice Addy's statement that the simple rule of common sense should govern. And I probably should close on that, because in family law, basically the law is very subservient to common sense. And the art and advocacy of family law, I suppose, is convincing a judge that common sense is on your side. Thank you.